Welcome everyone. My name is Will from Your Story Disability Legal Support. We'll start the seminar in a moment or two. We'll just wait for a few more people to join us. Okay. So my name is Will. I'm a lawyer with Your Story Disability Legal Support, and thank you for joining us today. I'd first like to acknowledge the Wayagal people of the Dharawal Nation, who are the traditional owners of the lands on which I'm hosting this meeting. I'd also like to pay respect to the elders, both past, present, and emerging, and to other Aboriginal and Torres Strait Islander people joining us today. So today we'll be hearing from Skye Webb and Anthony Levin from Legal Aid New South Wales Human Rights Group. And also from me, Will from Your Story Disability Legal Support, talking about the Disability Royal Commission. And this will be followed by a Q&A. And the focus for Anthony and Skye will be police complaints in New South Wales. A few points on housekeeping. The webinar is being recorded as well as live streamed to Your Story Disability Legal Support Facebook page. Auslan and captions are available. To turn on captions, go to the toolbar at the bottom of your screen and click on the button labeled CC Live Transcript and select Show Captions. Please post in the chat if you have any tech issues. And just a point on asking questions. On Zoom, please use the Q&A function to ask questions, not the chat function. You can ask questions anonymously if you wish to. On Facebook, please post your questions in comments. If we don't get to your question, we'll respond by email or Facebook, depending on how you're joining us today. If this webinar raises any questions for you, free counselling is available. Call Blue Knot on 1800 421 468. Okay, I will introduce our presenters now. Anthony is the Manager and Senior Solicitor in the Human Rights Group at Legal Aid New South Wales, where he's worked on and off for 16 years. He's been a member of the Law Society Human Rights Committee for 5 years. Anthony has special expertise in intentional torts, anti-discrimination law, and prison health issues. He has represented people with disability in both state and federal jurisdictions and published widely on legal and human rights issues, including in the Law Society Journal, the Judicial Officers Bulletin, and as a co-author of the chapter on prisoners in the Law Handbook. Outside of legal aid, Anthony managed a refugee resettlement program in the UK. Skye is a lawyer in the Legal Aid Human Rights Group team with a particular interest in claims against New South Wales Police Force and Corrective Services New South Wales. Before joining Legal Aid in 2019, Skye worked in the government law team at Henry York Davis and Norton Rose Fulbright, Australia. Her practice involved defending negligence and intentional torts actions brought against government departments. Okay, I'll share my screen and then we'll start with the presentation. Just one moment while we set this up. Okay, and now I'll hand over to Anthony to begin today. Thank you.
Thanks a lot, Will. Thanks for that introduction and welcome everybody. I'd also like to start by acknowledging that I am speaking to you today from Darug Guringai land, and I want to pay my respects to their elders past, present and emerging, and I acknowledge any Aboriginal attendees today or colleagues who are joining this webinar. If you just bear with me for a moment while I pull up my screen and reorient now that that screen is sharing. And then I will just briefly introduce what we're going to talk about before handing over to my colleague, Skye. Okay, so I thought I would just give you an overview of the objectives of this session, which are firstly to learn about relevant police powers, and hopefully if it's not you, Will, sharing the slides at the moment, if you could move to the next slide, whoever is sharing their screen now, because I know we had an issue with that earlier. And you can see the objectives there. Firstly, learning about relevant police powers. Secondly, building your confidence to identify disability discrimination issues, including recognising when police are providing a service, which is a critical issue. Thirdly, understanding different legal remedies, the complaint process and possible outcomes. And finally, exploring some practical tips to manage contact with police if you are a person with disability or you support people with disabilities. And a lot of that might come out in our Q&A session at the end of this webinar. What we're going to cover today on the next slide is listed here, but just before I go into that, a note about this training, and that is to say that it's worth acknowledging that bringing a claim against police is admittedly quite difficult, but there are multiple remedies available and some are more effective than others. So we're going to canvass some of the major barriers along the way. The fact that these challenges exist really only serves to reinforce the importance of engaging with the Disability Royal Commission while you still can. And so it's important that you use the services available both in your state through the Your Story legal support team to be able to do that. And you'll hear more from Will towards the end of this session about how you can do that. So we are going to cover police powers, we're going to cover remedies, the police complaints and torts, remedies that are available, disability discrimination law basics. I'll give you an overview, and we'll also talk about the remedies in that space, how you can resolve discrimination complaints. What we're not going to cover is the differences between jurisdictions. We'll touch on them very briefly when they arise and are relevant, but we simply don't have time for a jurisdiction by jurisdiction analysis today. We're not going to talk about reasonable adjustments or unjustifiable hardship, but we will touch on some common defences raised by police in this context. So I'm going to hand over to my colleague Skye now, who's going to talk to you about police powers. And I'm going to switch off and I'll see you all shortly.
Thanks, Anthony, and thanks everyone for joining us today. Before I start, I would also like to acknowledge the Gadigal people of the Eora Nation, who are the traditional owners of the land where I'm presenting from today. I would like to pay my respects to elders both past and present, and extend that respect to other Aboriginal and Torres Strait Islander peoples who are watching our webinar today. As Anthony said, I'm going to go through some key police powers. Anthony and I both practice in New South Wales, and so I will be using some examples from New South Wales legislation as I go through these powers, but it's important to note that the particular police powers do differ from state to state, and so we do recommend seeking advice from your state's legal aid service or equivalent in relation to any sort of specific incidents that might have arisen. Could we move to the next slide, please? Oh, sorry. Could we go back one? Thank you. So you'll see there a list of some of the key police, key powers that police might exercise. The first one there is the power to arrest a person with or without a warrant. And I'm going to talk a little bit more about the circumstances in which police might arrest without a warrant. As I said, the circumstances might vary from state to state. In New South Wales, police can arrest a member of the public without a warrant if they suspect on reasonable grounds that the person is committing or has committed an offence, and if they are satisfied that the arrest is reasonably necessary for one of a list of reasons that is included in the New South Wales legislation. And those reasons include things like to stop the person from committing or repeating the offence, or because of the nature and seriousness of the offence. And in New South Wales, police also have the power to arrest a person if they believe on reasonable grounds that a person has failed to comply with or is about to fail to comply with a bail condition. At common law in New South Wales, arrest is a power of last resort. And what that means in this context is that it is inappropriate for police to use their power of arrest in circumstances where a person has committed a minor offence, for example, an offence where the only possible penalty is a fine. The police know the person's name and address, and there's no risk of the person fleeing or no reason to believe that a court summons will not be effective. And that will become relevant a bit later when we talk about some common claims that might be available where the police have exceeded their powers. Another common power that we see police exercising are powers to stop and powers to search. If a person has already been arrested or is already in custody, then the police will generally have the power to search the person for that reason. But police do also have the power to search members of the public without a warrant if they're not under arrest or in custody. And again, those powers will be limited or confined by the legislation in your state. In New South Wales, there are 4 sort of circumstances in which police might have the power to stop and search a person without a warrant. And the officer must suspect on reasonable grounds that the person has on them something that's been obtained illegally, something that will be used or has been used in the commission of an offence, if they have a dangerous article on them, or a prohibited drug or a plant. And there are different kinds of searches that police might conduct or might subject a person to. Common searches are often referred to as frisk searches or pat-down searches, and that might involve an officer quickly running their hands over the person's outer clothing to see if there's anything, or if they can feel anything. And it might also involve the use of a metal detection device or a wand that we, quite commonly see. Another type of search might require the person to remove only their outer clothing. So that might involve asking the person to remove their jacket or a coat, might involve looking in a person's shoes. If the person's wearing a hat, it could involve removal of the person's hat. And that's often referred to as an ordinary search. And then the other type of search is a strip search. And a strip search is any search which goes beyond those parameters of the ordinary search. And it might include requiring a person to remove any clothes other than the outer layer. So a t-shirt requiring a person to remove, pants or shorts, or the police asking a person if they can look inside their underwear. Usually there will be additional thresholds before that the police have to reach before they can conduct a strip search, particularly a strip search that happens in the field or in public. In New South Wales, for example, a strip search, the circumstances must be urgent and necessary in order for a strip search to be conducted, and there are additional protections for those who the police want to strip search, including that the search be conducted in a private space and that the search be conducted by an officer of the same sex as the person being searched. In New South Wales as well, the legislation says that a strip search of a person, and I'm using the wording of the legislation here, a strip search of a person who has impaired intellectual functioning must be conducted in the presence of a parent or guardian or in the presence of a support person. So there are additional protections in those circumstances. An additional power to apprehend or search might arise under legislation that relates to involuntary detention of people in mental health facilities. And again, that will vary from state to state. In New South Wales, we have a piece of legislation called the Mental Health Act, which provides for the involuntary detention of people in mental health facilities. And under that act, police also have powers to apprehend a person and transport them to a declared mental health facility. And police may also be asked by authorised medical officers to assist in the transport of a person. Under that act, the police also have the powers to use reasonable force when they're exercising those functions. They have the power to restrain the person in a way that is reasonably necessary in the circumstances. And they also have the additional power to conduct a frisk or ordinary search of a person that they are transporting. The next common power there is the power, police have the power to use force in certain circumstances. In New South Wales, and I think in a number of other jurisdictions, the police may only use such force as is reasonably necessary when they're exercising their functions. And I've extracted the wording of the section in New South Wales on the slide there. And the key point to make here is this idea of a force that is reasonably necessary, and that's really important. We'll get to that again a bit later when we talk through the different claims that might be available to individuals who've been the subject of excessive uses of force by police. And just one last point to make about the exercise of police powers. Once a person is in police custody, there are additional protections for those who have disabilities. And again, I'm using the terminology from the New South Wales legislation here. What it says is that a person who has impaired intellectual functioning or a person who has impaired physical functioning is considered a vulnerable person under the legislation. And that means that when the person is in custody at a police station, the officer who is overseeing their custody must assist that person to exercise their rights, and in particular assist them to exercise the right to telephone a support person. And I think that's important to keep in mind. The other general point in terms of exercise of police powers is that police are also required to provide people with certain information when they are exercising their powers. And in New South Wales, that includes giving the person a reason for the exercise of the power. So if police are arresting someone or transporting them under the Mental Health Act, there is a requirement that they give the person who is subject to the power that reason. And could we go to the next slide, please? So I'm going to talk now about two options that are available to people who may have experienced unlawful or inappropriate behaviour from police. The first thing I'll talk about is a civil claim. And a civil claim is a claim against the police or the state seeking financial compensation for a civil wrong. And I think the key points about a civil claim is that the process may involve commencing proceedings against the police or the state in court, and the commonly these claims will be referred to as intentional tort claims. And in a court proceeding, if you are successful, the most common outcome that you'll get is financial compensation in recognition of the wrong that has been done. The next option I'll talk about is a police complaint, either to the police force or to an independent body, and each state has different independent bodies, which I'll talk about. Generally, a complaint won't involve any court proceedings, and it won't usually result in any compensation being paid to the complainant, but it may result in other outcomes or benefits that I'll also go through. So could we go to the next slide, please? So the circumstances that might give rise to a civil claim for compensation or an intentional tort claim include things like police using too much force or improper force, police arresting you when they should not have, police searching you when they shouldn't have, or police strip searching you when they shouldn't have. And this first type of claim that I'm going to talk about is called a false imprisonment claim. And a false imprisonment claim involves an intentional, total, and direct restraint on a person's liberty. And these types of claims are often made where a person is arrested unlawfully, so where police exercise their power to arrest without a warrant in circumstances where the legislation doesn't allow it. So the examples I've got there, first of all, an example where a police officer arrests someone for breaching bail conditions in circumstances where the condition has expired, so doesn't exist anymore, or the condition has been amended by the court. And since the Bail Act only allows arrest in circumstances where the police officer suspects on reasonable grounds that the person is subject to the bail condition and has breached it, if a person is arrested and detained in those circumstances, that could give rise to a false imprisonment claim. The second example there is where a police officer arrests someone and takes them back to a police station and detains them for using offensive language in public, even though the person gave them their name and address, was compliant, and police could have given them a field can, which I'm sorry in New South Wales is a court attendance notice instead. So this example goes back to that idea that arrest should be used as a last resort. That offensive language here in New South Wales is fine-only offence. And so in circumstances where police knew the person's name, the person was complying with police directions and so on, police just could have given that person a court attendance notice instead of arresting them and taking them back to a police station in those circumstances. So those are just some examples of where a false imprisonment claim might arise. And some other circumstances could include if police detain someone for the just on the street for the purpose of conducting a search. If the search is unlawful, then a false imprisonment claim could also arise for that period of time that the person wasn't allowed to leave and was effectively detained by police while they were being searched. There are other circumstances in which detention might be unlawful. Could we go to the next slide, please? The next type of claim is called a battery claim. And a battery is an act which directly and intentionally causes some physical contact with a person without consent. And that could include police touching a person's body during a pat-down or ordinary search in circumstances where the search was unlawful, or a police officer using excessive force during an arrest. It could also include police touching a person with one of their appointments or one of the items that police carry with them. So for example, using a baton or other, a taser or other appointments, that can still constitute a battery even if the police officer is not touching the person with their body. The example there is an officer arresting someone for offensive language, sweeping them to the ground and putting a knee on their neck to handcuff them in circumstances where the person is compliant. So we might say that doing those things goes beyond the force that was reasonably necessary in circumstances where the person was compliant, and that could give rise to a battery claim. The next type the next example there is, again, a police officer handcuffing a person to perform a pat-down search. In circumstances where the search was unlawful, then the application of handcuffs could also be considered a battery and could give rise to this kind of claim. Could we go to the next slide, please? And the last kind of claim that I'll talk about today is an assault claim. And battery and assault claims are often made together at the same time, but they don't have to be. They are standalone causes of action as well. An assault is any direct and intentional threat made by a person that places the plaintiff, and I'm sorry, that's the person who might bring the claim or make a complaint, places the plaintiff in reasonable apprehension of imminent contact with their person, either by the defendant, being the person who's made the threat, or by something within the defendant's control. So again, that includes police appointments in this context. So the example there is a police officer drawing their taser or perhaps their OC spray can, pointing it at someone and giving a direction, saying, lie down on the ground or I'll fire or spray you. That's the sort of circumstance in which you might, the person might experience an assault, and then if the officer does then move to use the taser or OC spray, it could give rise to both an assault and a battery claim. Could we go to the next slide, please? This is just a brief overview of the process of making a civil claim. You'll have, a lawyer or legal representative who might investigate your claim and the merit of making one. They might decide to send a letter that's called a letter of demand to the police prior to actually starting a court case, and then seeing if they can negotiate with the police or hold an informal settlement conference to try and resolve the matter without the need to actually go to court. And those are in italics there because they won't always happen, but that might end up with your claim being settled without needing to commence court proceedings. If you go on to commence court proceedings, you'll file a document called a statement of claim. You'll have, again, an informal settlement conference or a mediation. At that stage, your matter might settle, which means it resolves without you going to a hearing, or the matter might proceed to a hearing where the court makes a decision and gives a judgment about whether or not what the police did was unlawful, and if so, how much compensation you might be entitled to. I think it's important to note that the civil process, this process will take time, and it can take quite a long time, which is something to keep in mind. And usually if a matter settles either at the pre-litigation settlement stage, so before you've started court proceedings or after you've started court proceedings, the person may be asked to keep the outcome confidential as part of any written settlement agreement. And that's quite common. And any court proceedings, if it proceeds to the hearing stage, that will involve the person having to give evidence at the hearing, which can sometimes be really difficult for clients having to relive the things that happened to them. Could we go to the next slide, please? There are different time limits to make these kinds of claims. I think worth noting that the time limit in most states is 6 years, except for the Northern Territory, which is 2 months, and Western Australia, which is 3 years. There might be circumstances where the time limit is suspended if a person is unable to manage their affairs by reason of an impairment of their physical or mental condition. But again, that's state specific. And so if you do have any questions about time limits or circumstances where they might be suspended, really important to get legal advice about that. And I will say as well that if a person has suffered an injury as a result of contact with police, then there may also be different types of claims available that I haven't talked about today, and different time limits which apply. So it's really important to get legal advice in circumstances where there are any serious injuries or injuries. Could we go to the next slide, please? So I'll move on now to talk about the sort of complaint options. In addition to that sort of civil claim, there are options available for making formal complaints against the police. So you could make a written complaint directly to the police force, or a written complaint to the relevant independent body in your state or territory. And in terms of complaints, the scope or the behaviour that you can complain about is broader than the behaviour that might give rise to an intentional tort claim. So in general, you can complain about any inappropriate police behaviour. You could complain in the circumstances that we talked about earlier that might give rise to a civil claim, but also any other situation. So for example, police, and one thing we get asked about a lot is police harassment, which might not reach that sort of level of unlawfulness that gives rise to a claim. In those circumstances, certainly a complaint is an option, and we'll talk about the benefits of complaints in a minute. We'll just go to the next slide, which lists the independent complaint bodies that are different in each state. In New South Wales, which I apologise is not in that list, the independent body is called the Law Enforcement Conduct Commission, otherwise often referred to as the LEC. But you can see there that each state does have a body that can accept complaints about police. We'll just, oh yes, and sorry, there's just a note there, we'll be sending the slides around, so please don't worry about noting all those down. If we'll move on to the next slide, please. So here are just some sort of benefits that might come from making a police complaint. In some circumstances, a complaint might lead to a change in police practices. It can give clients some satisfaction to know that the matter has been reported, that someone has raised it with the independent body, even if the complaint is not ultimately sustained or no action is taken. It can provide evidence of what happened, which might be able to be used in the future for other advocacy, creates a record of the complaint and of the behaviour, and it can also be beneficial in circumstances where an independent body is seeing a large number of complaints about a particular issue or about a particular area. It can also be beneficial there in prompting them to take action about those issues that they're seeing. We had a question, and we get asked this a lot, what to do about police harassment in circumstances where a person doesn't want to make a complaint. It can be really difficult. One thing to know is that if a person does make a complaint and is then subject to further police harassment or victimisation, that would be grounds for making a further complaint, which should be taken more, might involve oversight by the independent body. So in New South Wales, for example, the LEC has the power to monitor and oversee police complaint investigations, and a complaint about victimisation may be something that is monitored. You could also consider, and Anthony will go on to talk about this, a discrimination complaint, and further victimisation on the basis of a complaint being made is prohibited by the relevant anti-discrimination legislation, which Anthony will speak to, as I said. And the other option, if a person's concerned about making a complaint directly to the police, is to consider a submission to the Royal Commission, which Will speak about later on. And then just the next slide, and this is my last one. There's no strict time limit generally to make complaints to either the police or independent bodies about police behaviour, but ideally we do recommend making complaints within about 12 months. It is possible that complaints may be declined, or police may choose not to investigate them if the events happened too long ago and they're unable to find sufficient information. So that's me done. Thanks very much, everyone.
Thanks, Skye. So we're now going to talk about disability discrimination law. And I just note that in this section, there are going to be a couple of quizzes, and instructions will be posted in the chat. Unfortunately, there are no prizes apart from glory and a sense of fulfillment that you answer the questions correctly on a Friday. So look out for those in a few moments. I just thought we'd start by doing an overview of the state and territory legislation. There is a discrimination law in every state and territory, And they are all slightly different, which just makes things exciting for discrimination lawyers like us. But there's also the federal legislation, and today's focus is on the Disability Discrimination Act, which is on the next slide. That's the focus partly because it applies to everyone who's attending today. And for lack of time, it's difficult for us to go into all the different sort of discrepancies and differences between each law. So if we can move on to the next slide, thanks, Will. Thank you. So just to give you an idea of some of the basics in discrimination law that covers disability. Many of you will know these, but I thought it worth recapping how disability is actually defined. So it does cover things like loss of bodily and mental function or partial loss or partial loss of the body, disease, illness, learning disorders, malfunctions or malformations of the body, or disorders, illnesses, or diseases that affect cognition, perception, judgment, emotions, or behavior. Now, on the next slide is just a reminder that's relevant to this COVID or post-COVID era, which is to say that it's not unlawful to discriminate on the grounds of a person's disability if the person's disability is an infectious disease, and discrimination is reasonably necessary to protect public health. We might touch on this issue again a little bit later. Thanks, next slide. Equally important is to note that the DDA covers disabilities that you had in the past, that you have now, that you may have in the future, or that someone assumes you have, and we call this an imputed disability. Next slide tells us that it also covers the various mobility aids and assistance and facilities that people use to support their disability. So if someone discriminates against you or your client on the basis of their aid or their assistance animal or their interpreter, those things are covered by the law, and the law says that it's as if you've been discriminated against because of your disability itself. Okay, next slide. So disability law is complex, and it generally defines discrimination in two key ways. There's a kind of dichotomy between direct disability discrimination and indirect. And sometimes we say that the difference can be explained in this way, that direct discrimination involves treating someone differently or differentially to someone else who doesn't have their disability in similar circumstances. And to establish it, you need to show that you are a person with a disability, that you've been treated less favorably, that less favorable treatment is compared to someone who doesn't have your disability or doesn't have a disability in the same or similar circumstances. So let's look at a little scenario in the next slide about Lydia. Now, Lydia has a disability called ataxia, which causes loss of balance and coordination and slurred speech. A police officer refuses to help her after her bag is snatched in the street because he assumes that she is intoxicated. And we know that this happens to people who have this particular disability. That's just illustrating a form of direct disability discrimination. But we'll go into how this kind of sometimes isn't a clear-cut distinction. On the next slide, we're going to talk about indirect disability discrimination, sometimes called facially neutral, which means it's fair in form, but discriminatory in operation. Now, to establish the elements of this claim, you have to show that there was a condition or requirement imposed on you. And you must do that quite precisely. You have to say that the person with disability can't or doesn't comply, that the condition itself is unreasonable, and that you or your client have suffered some form of disadvantage. And there's a difference which, I thought I would just point out a difference between the New South Wales law and the federal law to show you how discrimination law can be quite complicated and requires legal advice. And that is that in New South Wales, the onus is on the applicant to establish that the condition is unreasonable under the Anti-Discrimination Act. But under the federal law, that onus is actually on the alleged perpetrator. Let's look at another scenario, scenario 2 about Jason. Jason is an Aboriginal man who has a mental illness, and after allegedly abusing members of the public, he was arrested and taken into custody. Now, during his time at the station, he says police threatened to hurt him, punched him, took an hour to arrange decontamination after spraying him with OC or capsicum spray. And when he asked for water to wash his eyes, one officer said, "You're not in the psych ward anymore, mate." Now, this scenario was actually based on a real case from 2017 in the New South Wales Civil and Administrative Tribunal, although I've adapted the facts a little bit for today's purposes. So there's a couple of other areas of unlawful discrimination I'd like to touch on, and we will return to Jason in a moment because this particular scenario in scenario 2 raises issues about whether Jason is receiving a service from police when he's in custody. And that is a critical threshold issue. So we're going to come back to that. But first, let's just talk about these two other areas on the next slide, which is that the DDA also makes it unlawful for police to harass a person with a disability in relation to their disability. And that harassment must be persistent action that's likely to humiliate, offend, intimidate, or distress the person. Now, a key proviso here is that harassment is not the same in this situation as the kind you might be familiar with in lay sense, or even if you have an understanding of what sexual harassment is under the law. And that's because unlike sexual harassment under the Sex Discrimination Act, disability harassment has been interpreted by the courts somewhat unfortunately to mean that it must be persistent. So typically a single incident won't meet that threshold, and you need to point to a kind of pattern of persistent practice, action, or conduct. The second area that's unlawful is to victimize a person with a disability for asserting their rights under the DDA, such as making a discrimination complaint. And the coverage of this provision is pretty broad at section 42 of the DDA, by the way. And its breadth means that it covers not just making a discrimination complaint, but asserting a right under the DDA or the Human Rights Commission Act, alleging that someone has done something unlawful under those acts, or asserting any other right under one of the federal discrimination laws. And it will be similar in most states and territories that there will be a provision that protects victimization. Okay, we'll move on to the next slide and we're going to return to Jason. So one night, a few weeks later, two police officers driving down High Street spot him coming out of a nearby park. And they pull up beside him and they start talking to him. But Jason doesn't want to talk to them and he's on his way to a shelter. The male officer calls out, "You're a bit far from hospital, aren't you, mate?" And as Jason walks away from the car, police continue to drive slowly beside him, shouting things like, "Do you need another shower in a can? Look at your skin, you're filthy." And Jason feels frustrated, frightened, and he yells back abuse. And so as a result, he is stopped and searched. Now, this scenario draws our attention to an important point, which is that discrimination can be intersectional. It recognizes that sex, race, gender, identity, cultural background, and other attributes can actually compound disadvantage, and they can intersect with disability when you're interacting with police. So you can bring claims based on more than one protected attribute. And that's what we call them in disability discrimination law. Now, this raises a couple of those issues because comments made in this scenario imply that police are aware of his mental health disability, the references to taking him to hospital or him being far from hospital. But there's also an inference or an imputation about the color of his skin or his race. And so you might make an argument, if this person got some legal advice, that he should bring a claim based on both race and disability. Okay, so we'll move on to the next slide. And we're just going to talk now about how police are covered by anti-discrimination laws. And the first thing you need to do is think about what area of life police are operating in that is protected by the law, especially the DDA. Typically, it's goods, services, and facilities, which is protected by section 24. And the critical question here is it a service? Is what police were doing a service? And the answer is derived from the principles in the case law, which is somewhat unhelpful, but that's what we have. So in the next slide, we're going to talk about the areas that have been recognised by the courts. So the courts have said that police are covered when they are offering protective help, and that generally means something that's beneficial or that supports a person's welfare. When they are detecting or preventing crime, and that can include preventing disturbance of the peace. When they're responding to requests for help or, as I said, offering help, and that can include even where someone asks for help and then they give them a move on direction, that can still be covered. Or finally, if they are preventing injury or death or protecting property. These are not exhaustive categories, but they are the ones that have been recognised, and it is relatively difficult to establish that police are providing a service to a person. That is a threshold question and is sometimes a reason why people's discrimination complaints fail. So what about what's not covered on the next slide? Well, what's not covered is when police are investigating an alleged offence, when they're questioning or arresting an alleged offender, dealing with a bail application, deciding to lay charges or apply for an AVO, deciding whether to prosecute, serve a summons, executing a search warrant, or considering bail under the Bail Act. And it even means that when police are entering data in their database, which is called COPS, they're not covered then either. Okay, so before we move on to another scenario, I just wanted to mention that there are some commonly raised defences, and one of them is that police will frequently point to their need to exercise a statutory power, and that is covered under the DDA by a defence that says if they need to comply with another law, then that is a valid defence to a claim of disability discrimination. And there are others which we unfortunately don't have time to go into today, but they're listed there. Let's look at scenario 4. This is based on a decided case, Derek and the State, which was in the New South Wales Civil and Administrative Tribunal. And in this case, the applicant, who has a mental illness, alleged that he was a victim of extortion, stalking and harassment, and that police discriminated against him on the ground of presumed disability when an officer refused to help him, firstly, and then referred him to a mental health service. Now, what do you think happened here? Well, the tribunal accepted that taking action to investigate a matter in response to a complaint by a member of the public can be a service to that person. But the only evidence that Mr. Derek had that supported his claim was that he was referred to a mental health service. And the tribunal said, well, that's not logically enough to support your inference. And there was in fact evidence to show that it was done as part of the respondent's duty of care. And this really draws our attention to that fine line between offering help, which might be a service, but offering help which is actually part of a duty rather than being something discriminatory. It's worth saying here that most discrimination cases against police are difficult to bring. They tend to be based on race more than other protected attributes. There are very limited cases on disability, and of those even less that are successful. Although I would note that the conciliation rate for bringing discrimination complaints at the Human Rights Commission is very high. It's about 70%. So even though a lot of cases don't make it to tribunal or court, many of them do settle. It's also worth thinking here about you should go and get advice first. And if you get advice that says your discrimination complaint lacks merit, you might still be looking at other remedies which Sky has covered and thinking about, well, is it worth claiming that you were discriminated against on another ground that's not protected by the DDA, but can still be brought as a police complaint? And the parameters of the police complaint system, certainly in New South Wales and in most states, are that they cover discriminatory practices more generally. Okay, so it's time for a quiz. And I will just remind you with a few brief instructions about how this is going to work. So it's a short multiple choice quiz. My colleagues Fiona and Kim are going to share those instructions now. There are 4 questions. If you're joining on the Zoom, they should appear on your screen now, and you need to select your answer and then click submit. Your answers are anonymous, and if you don't want to take part, you don't have to. You can just close that screen. We will briefly display the answers at the end of the quiz in a few moments. If you're joining on Facebook, the questions will be posted in the comments, and to respond to a question, you just reply with your comment. And please be aware that your answers there are not anonymous, and your name will be visible to others on Facebook. So let's just let people have a go at that and wait for the answers to roll in. And then we will look at the results from the Zoom in a moment. Okay, I'm going to wait for a cue from my colleagues to tell me when the results are in. About 20 seconds left. Got to be quick here. Okay, any moment now, I think we're going to have our results. Here they are. Question 1, is it lawful for police to arrest someone who's coughing a lot on the train because they appear to have an infectious disease? True or false? Most of you got this, 93%. The answer is false. Police must establish that the disability is an infectious disease and the discrimination must be reasonably necessary to protect public health. There's a couple of barriers there. Question 2, a woman with a prosthetic limb is arrested and a prosthesis is removed and confiscated. As a result, she can't move around the police cell. Is she covered by the Disability Discrimination Act? 100% answered yes. Excellent. She is. She has a recognised disability. There is a threshold question here, and that brings us to one of the other questions in the quiz. We'll get to that in a second. Question 3, is her experience likely to be direct or indirect? This is a tough one. Don't worry if you hedged your bets. In my view, it's likely to be indirect, but because we are wily discrimination lawyers, we would probably argue direct discrimination in the alternative as well. And that just exemplifies that it's not always clear. There's an important caveat here, which is you cannot argue both direct and indirect discrimination arising from the same incident or specific fact. Sometimes a set of facts will give rise to multiple incidents of discrimination. And you might say, well, point 1 in the sequence was direct, but points 2 and 3 were indirect. And lawyers look very forensically at that stuff to work out where the direct is, where the indirect is, or whether it's better to say, actually, it could be either or, and we're going to hedge our bets, and we're going to argue strongly for this one. But in the alternative, we think it could be direct as well. And that's probably what I would do here. The other thing worth noting here is just that the circumstances of the removal of the prosthesis might change the answer. So if it was removed during a search in the street, that could change the answer about whether the person is covered, because we might be saying, well, that's not a service. A search is not a service. But if it's removed after she's conveyed in a police vehicle or when she's in the police cell later, then that could mean that we're saying, yes, there is a service here. We're going to touch on this. This is a theme that's going to recur. Let's look at that last question, which is, are police providing a service? If your answer is yes, what is it? I think my results have gone, here they are, they're back again. Most people answered no, some answered yes. It was about a 36, well, it was a 40-60 split almost. I would say yes, and the Supreme Court of New South Wales has said so too. What they've said is that as soon as someone has been formally arrested and they pass into police custody, the police are providing them with services, including protecting them from injury or death. And in my view here, they would need to protect the person from injuring themselves because they can't walk around or stand up in a stable way. Now, if your client were lying down on the floor the whole time, that may not arise. But if they were trying to move around to stretch or just to, because they were nervous or anxious, then it could become relevant. Okay, so thank you for humoring me by doing that quiz, and let's move on to the next section. On the next slide, we're going to talk about the complaint system. Now, before you lodge a complaint, it's worth thinking about a number of different factors and considerations. And we've developed a tip sheet for you to help you with that. I'm not going to speak to it now. You're going to receive it after the session. And we advise you to kind of keep it handy when you're working with people so that you can work through these suggestions because you may find them helpful. Okay, on the next slide, why would you make a discrimination complaint? Well, there are multiple reasons. One is because you might have tried to resolve it locally and that didn't work. Another is you need information that you can't get any other way. Sometimes having an independent person, a conciliator, can help to elicit that information. Another is you feel you're not being taken seriously. So that could be a good reason to make the police force in your state or territory pay attention. You may be seeking a public interest outcome or a systemic impact to prevent this thing from happening to someone else. Or you might just want a formal discussion around a table to feel heard and to feel that you can get answers to questions, understand why particular powers were exercised or why particular conduct happened. Okay, on the next slide is a list of all of the discrimination forums in your state or territory. We don't have time to talk about them all, but they do operate in a rather similar way. Our focus today is on the Human Rights Commission, and the next slide shows us what that complaints process looks like. And what it looks like is you would lodge your complaint. Our preference would be after you'd sought some legal advice. It would be acknowledged, then assessed, and in some circumstances it could be declined if it lacked merit, but if it were accepted, it typically proceeds to a conciliation conference, and that's a bit like a mediation. There'd be a conciliator there who's present. Their role is to support the parties and to try and get the parties to come to agreement and resolve the dispute. Now, if the dispute doesn't resolve, then you may end up in a tribunal or at the federal court. And in the federal system, you have 60 days to make that decision. You don't have to go to court though. You can choose to walk away at that point, even though you may not have achieved your desired outcome. Again, we've developed a bit of a checklist for you about the complaints process. You will receive that after the webinar, and we recommend that you keep that handy. If you have any feedback about that, we also welcome your feedback through the survey, which you'll also receive. Now, one important point, and as we near the end, is time limits. These are critical. Generally speaking, you will have 6 months to lodge a complaint at the Australian Human Rights Commission. There is one exception, and that is for sexual harassment or sex discrimination claims. We're not talking about those claims today, but because discrimination can be intersectional, you might feel that you or your client has been discriminated against on that basis and for their disability. So you have to then think about how you frame the complaint, and I would say that you'd be looking to argue that the longer time limit applies, but lawyers are cautious and we would probably treat it as attracting the shorter time limit of 6 months. In your state or territory, certainly in New South Wales, it's 12 months, but you should always check the time limit in your local area or jurisdiction and seek legal advice about that. A note about this, these are not hard time limits. There is discretion in both the federal and state laws. And sometimes complaints are received out of time. However, we know that there is significant delay right now in processing complaints at the Human Rights Commission, a delay of about 6 to 8 months. And that may be a reason why a complaint could be declined if it was out of time. So a lawyer worth their salt would make submissions about why it's late, and there are often legitimate reasons for that. But generally speaking, you want to avoid that because you just don't want to be in a situation where your complaint is knocked back because it's a few months late. And that really comes down to the particular agency being inundated with complaints and needing to look for reasons, you know, to decline it. My experience is that that doesn't happen, and especially in the federal system, the Human Rights Commission will try to find ways to get the complaint in. Okay, on the next slide, a few possible outcomes, and this is really important to think about, similar to some of the content that Sky covered a little earlier. One of the most common outcomes that you might be seeking is compensation or damages. But that's not always the case. And sometimes people specifically say, I don't want money, I want an apology or a letter of acknowledgement, which is kind of a way that governments often apologize if they don't want to say that they've done something wrong expressly. You might want training, or your client might be seeking a policy or procedural change. They might want a reasonable adjustment if there's a continuing relationship and they want to be treated fairly. And finally, and perhaps the rarest outcome, is judgment, where you go to hearing, you succeed, and you get a judgment against the other party and orders are made. I also thought I would just make a comment here about how the legal system remedies harm. Now, if the harm your client experienced doesn't amount to disability discrimination as the law defines it, then you should still seek legal advice, because there could be another way to address the misconduct or the abuse of power. For example, just touching on content that Sky covered, if there's a claim in tort because you were wrongfully arrested or assaulted, sometimes the disability might be relevant to the way you were treated, but it's not a provable reason for the treatment that you received. And in those circumstances, it's possible to account for the harm in other ways, for example, through damages. So the courts and tribunals can award what are called aggravated damages if your subjective experience was particularly humiliating or distressing. This would more apply in the tortious context in a court. But they can also award punitive damages against police for consciously ignoring your rights. And those are things that lawyers will always think about. There are a few advantages of making tortious claims over discrimination complaints. One is that the time limits are longer, as you will have seen, apart from in the case of the Northern Territory. Second is that liability is strict. And the third is that the damages tend to be higher. So those are all things worth thinking about, but again, things that you're likely to discuss with a lawyer. Okay, our final quiz. I think we have time. I hope we have time. We can sort of race through it. There's only 3 questions. The first is, should pop up on your screen now. The same instructions apply. You can just click on your answer and submit. What is the time limit for discrimination complaints to the Australian Human Rights Commission? Question 1. And question 2, if your complaint fails to resolve at conciliation, you must go to court. Is that true or false? Question 3, because police have the power to take someone to hospital for mental health assessment, anything they do in that time is lawful and not discriminatory. Is that true or false? I will give you a few moments to enter your answers. Because it's anonymous, I'm not going to be able to pick a winner, someone who got them all right, but you will know, and that's the important part. Okay, we might move to the next slide just so people can see them that way as well as an alternative. Thanks, Will. Okay, how are we going with the results? 30 seconds left. Okay, just a few more seconds. Okay, the results are in, and we'll just have a look at question 1. So not everyone has answered this one, it seems, but most people have answered 6 months for all types except sex discrimination, 64%. And if that's what you answered, you'd be right. Question 2, if your complaint fails to resolve a conciliation, you must go to court. True or false? Most people said false, and that is correct. You can choose not to go to court. And the last one, can police basically do anything they like if they're taking someone to hospital for a mental health assessment? That is false. Almost everyone got that right. Police might still be providing a service when they're conveying somebody to hospital. They might still need to, they do still need to protect the person from injury or death. So most of you are right on top of that. And this is just a good way to test understanding anyway and reinforce the knowledge that we're sharing with you today. There's one final thing to say, which is just that if you are in New South Wales, you can seek legal advice through Law Access. The number is there on the screen. You can also go to the Legal Aid New South Wales website for access to our resources or other services. Remember to contact the Your Story Disability Legal Support team. Will's going to jump on in a moment and talk more about that. And you will undoubtedly have a community legal centre near you. Go to the Community Legal Centres Australia page and you can search by postcode and find what your nearest centre is. A quick word finally about the discrimination toolkit, which is a resource we have developed with our colleagues in the CLE team. It's available as a recording on YouTube, the link is there, also as a download from our website, and there'll be a new version available soon. Thanks very much, everyone, and I'm actually really looking forward to your questions in the Q&A in a few minutes, so I'll see you in a sec, and I'm going to pop my camera off and hand over to Will. Thanks.
Thank you, Anthony, and thank you, Sky. So this last section will be quite brief, only 5 or up to 10 minutes, just talking about one other option if you have issues with police, and that is talking to the Disability Royal Commission. So today I'll just explain briefly what the Disability Royal Commission is and what our service is, Your Story Disability Legal Support. Okay, so the Disability Royal Commission. So as many of you might know, the Royal Commission has been on since 2019, and it's a federal or national government inquiry into the mistreatment of people with disability. It's looking at the experiences of people with disability in all settings and contexts, in the past and in the present. And so that includes police interactions, such as experiences in police custody, with police in the community, or during a police check. One point that is important to raise is that disability is defined differently with the Royal Commission compared with the other areas of law covered today. For the Royal Commission's purpose, disability is any kind of impairment. So that could be a mental health, a physical disability, psychosocial disability, brain injury, intellectual disability, a learning disability, any kind of impairment. Okay, and finally, the whole point of the Royal Commission is for the government to learn about what is happening and take on people's stories so that they can deliver reports to the government with recommendations for what laws and systems to change. So how to tell your story? It can be in any format at all. It can be in writing, but it doesn't have to be. It can be by phone or by a video format or audio format, and it can be in any language, non-English language, including Auslan. And it can be as public or as private as you like. And that's something that you can talk with us about if you're not sure. And finally, it doesn't have to be your story. It can be a story about something that's happened to somebody else. someone that you know professionally or personally. And so where do we fit in? So Your Story is the free independent legal advice service for anyone who wants to talk to the Disability Royal Commission. Our service is free and it is separate and independent from the Royal Commission. We work on a trauma-informed basis, so all of our staff have extensive trauma-informed practice training. We are also culturally safe, so our service is run through all of the legal aid commissions and Aboriginal legal services and Torres Strait Islander legal services across the country. So clients who are First Nations can decide if they would like to speak with someone at a First Nations controlled organisation or not, if they don't want to. And finally, we are a very flexible service and do everything that we can to accommodate, to make sure that we engage with you and give legal advice with you in a way that works best for you. Okay, so our clients are people with disability, but also their family, carers, supporters and advocates, as well as anyone in the community who would like to talk to the Royal Commission and provide recommendations. Our service is primarily information giving and advice giving, legal advice for people talking to the Royal Commission. But we also do provide a lot of referrals for other legal issues. For example, police complaints would be one of those we could refer to other legal aid commissions or community legal centres, or whichever is the appropriate legal referral. And we also have a big focus on non-legal referrals, especially to other Disability Royal Commission funded support services. So that includes disability advocates and counselling services that are also free and funded through the Royal Commission. And our approach is we have no wrong door. So if you're not sure where to start, and if you're thinking about talking to the Royal Commission, you can call us or contact us in the way that works for you, and we will direct you to the right place. Okay, there's just our details here for how to contact us. And one final takeaway I will add in there is that the Royal Commission does end at the end of this year. So if you do want to talk to the Royal Commission about any of your experiences, it is important to get in contact with us or with the Royal Commission as soon as possible. And thank you so much for listening to all of our presenters today. I'll stop sharing my screen in a moment, and we will have some time for questions. Okay, just one moment. Okay, perfect. So just a reminder on questions. If you are on Zoom, please use the Q&A function to ask questions, not the chat. You can also ask questions anonymously if you wish. If you're on Facebook, please post your questions in the comments. And if we don't get to your questions, we'll respond via email or Facebook, depending on how you're joining us today. I do have a few questions that have been asked of us in advance, which I might start with, and then we'll open it up to other questions that come through. The first question is what to do when police refuse to help after a violent assault and despite an ongoing stalking despite evidence. I believe Sky did cover this during the presentation, but I was opening up to see if there were any further comments from you, Sky, or Anthony, if you had anything to add from your perspective.
Guy, did you want to jump in first?
Yes, I think in those circumstances, in terms of the content, I discussed a police complaint or a complaint to an independent oversight body would be an option in that situation. And as I think I touched on briefly, if you made a complaint and nothing happened, or the police wouldn't accept or investigate the complaint, that could warrant a further complaint to the oversight body again on the basis that police had also not responded to a complaint appropriately, which in some circumstances might prompt further oversight of the police complaint process as it relates to that particular situation. So I think that would be an option there.
Yeah, look, I would only add that one of the difficulties in this space is that police have an awful lot of discretion about what they choose to investigate, and it can sometimes be difficult to look behind that discretion in whether they prosecute something or not. This is truly one of the harder areas of dealing with police conduct or behaviour. Excuse me. And I would only reiterate that this is another reason why, if you feel that this has happened to you or a relative or a person you work with, that feedback needs to be ventilated through the Disability Royal Commission if you haven't already, and you can talk to the Your Story team about making a submission before the end of the year. It's useful to make complaints about that under the police complaint system, either through your local police or the watchdog in your state or territory, because that may elicit the reason why they didn't prosecute and explain something that you didn't know. And the standards of evidence, can be quite high for certain kinds of offences, and sometimes that's not necessarily obvious to us who don't practice in criminal law. Finally, I would just add that it's worth also thinking about whether there was a discriminatory element in that particular scenario, whether one of the reasons why you are not receiving that service from police or they are not prosecuting a crime is because of your disability, for example. And it need only be one of the reasons. It doesn't need to be the dominant one. Hard to prove, but worth getting legal advice about. I hope that answers the question.
Thank you both. One more question we have here is, what advice would the presenters give to clients who are experiencing police harassment and are concerned about that harassment escalating if they make a complaint?
Sky, I'm going to let you.
Yeah, I think I did try to touch on this briefly. I think, again, harassment can be a really tricky one, particularly in circumstances where someone might be concerned that it could escalate. Again, making a complaint to the police or an oversight body is an option. I think, as we sort of discussed, another option could be if the harassment could be connected with a protected attribute under the discrimination law, like a disability. If you assert or make a complaint about the disability, or even just assert that that could be one of the grounds, you may be protected by the victimisation, the prohibition on victimisation in the DDA and the other anti-discrimination legislation, which could then be of a further ground for a complaint to one of the anti-discrimination bodies. So that's something to think about. Anthony, did you have anything to add there?
No, I think you've covered it. Thanks, Sky.
Thank you. A few questions have come through. Is there any advantage in claiming one type of discrimination over the other, such as direct or indirect? Is there a difference in available remedies?
Yeah, I'm happy to take this one if you like. There's no difference in remedies. The remedies that are available are the same, so we can sort of knock that out. And in a way, especially because you pass through a conciliation process first, the remedies available are as wide as you are creative. So if you can think of something, you can propose it, and a conciliator will try and help you get there. As far as the first part of the question goes, advantages, I guess the general answer is yes, there can be forensic advantages in arguing for direct or indirect in particular situations. I think that's what the questioner is directing our attention to. And that's pretty technical and might come down to the particular laws in your state or territory, or whether you've gone for the federal law. As I said earlier in the presentation, there are some differences between them, and sometimes those differences are quite meaningful. For example, sometimes I will tell a client, look, you are better off in the federal system because the law is more protective, or because a disability standard applies that doesn't apply at the state-based level. Those standards we haven't talked about today because they cover transport, accommodation, and another area, and there is discussion that there should be one for employment, but they generally don't cover situations involving police, which is why we didn't talk about them today. Those forensic advantages are generally things that lawyers will think about. I guess I'm just sort of thinking out loud for a moment about what else we might turn our minds to. Sky, can you think of anything else that might play into that decision?
No, I think you've covered it in terms of the you know, the differences in the legislation will be a significant consideration there in terms of how you frame a complaint.
Yes, that reminded me of one other thing actually, which is the other thing that we need to think about, and barristers think about this too, is what's the story we're telling, you know, and we're here collaborating with our colleagues in the Your Story service, and that's what discrimination law is about. If you want to succeed, you've got to tell the story, and it's got to be a story that makes sense to the decision maker. So sometimes there'll be an advantage in choosing one type over another if we think both are available on the facts, because we think the story is clearer and simpler. And again, those are forensic decisions that we make. Yeah.
Great, thank you. We have a number of questions coming through, so we might be able to get to one or two more before we wrap up. We have one question here. Is it true that if a person with severe disability commits a crime, the police might not be able to file charges if the disability prevents them from realizing what they did was wrong, or the crime they committed was part of their disability, such as impulsive, offensive language because of Tourette's syndrome?
Yes, this is a good question. A tricky one for us to answer because neither of us are criminal lawyers, so we are not comprehensively across all of the possible answers to this question. I'm generally aware that a person can seek to plead not guilty by way of mental illness. That is something that they would need to discuss with their criminal lawyer, or indeed an assessment their criminal lawyer would need to make about the person. The other time when this has come up in the course of our civil practice is where we sometimes talk to our colleagues in crime about people who have reporting conditions that are pretty onerous that they can't meet because of their disability, which is somewhat similar to what this person has asked in this question. And those reporting conditions might mean that you've got to attend, you know, station every day for a register or some other bail requirement. And because of a person's disability, it might impede or inhibit them from doing that. Those are very difficult things to argue. And there isn't a clear way of making that argument in that context. But in this context, whether, for example, having Tourette's syndrome would mean that you had a particular defense, that may be so. It would depend on establishing it for the particular offense that's been charged. if there's a mens rea element, which means was there an intention, a mental intention element to the offending, if that is a part of the offence, then you may not, the prosecution may not meet that element if the defence can show that the person lacked that intention because of their disability. Now, I'm talking about this at a very high level. I am not an expert. This is not legal advice. And so I guess I would just say that is a possible way of approaching that, but very contingent on the offence itself, the nature of the disability, and how the disability manifested in the particular situation. And and I would just remind people to seek criminal law advice about those kinds of things.
Thanks, Anthony. Are there specific criteria that police have to show were present for them to have reasonable grounds to arrest someone or search someone, or that the force used was reasonably necessary? How do they define reasonable in these circumstances?
Anthony, I can try to answer that one, and then perhaps you can let me know if there's anything I've missed. There aren't really specific criteria as such. In terms of arresting and searching, there are there's lots of case law, lots of decisions around these, the exercise of these powers, but in general, police do have to have some kind of objective basis on which they've formed their reasonable suspicion. They've got to have some basis for that suspicion, and it really depends on the particular facts of the case and the circumstances of what happened. It's hard to make a sort of generalized statement about it. In terms of the force, that again will really depend on the circumstances of what happened, and things like was the person resisting arrest, or what was the person doing, and whether the response by police was proportionate, and those sorts of ideas might come into a consideration of whether the force used was reasonably necessary. But it's, there's no sort of clear definition of reasonable, which is what makes these claims difficult to prove sometimes.
Yeah, I agree with that. And what the courts have said is that it's pretty permissive, actually. They say police make hard decisions. They operate in an impressionistic world, and it's not the job of the courts to review their conduct with a fine-tooth comb. They operate in the agony of the moment, and they make quick decisions under pressure. And all of those things are a way of kind of sometimes explaining why a choice made by a police officer to use force may not have been optimal, may not have been the best choice, but was a legitimate choice to use in that particular situation. And Skye and I are thinking about this all the time because we run lots of use of force cases. And I've got a little thing stuck on my monitor here, which just reminds me of some of the criteria that we think about. And in addition to the ones that Skye mentioned, they do look at things, the courts and lawyers, when they're assessing merit, look at things like what was the offender doing at the time, what was their subjective mental state, how many officers were at the scene, what was the level of threat, was it immediate, was the person resisting? Skye already mentioned the number of police, the stature of the person, their position, whether they had a weapon. There are all sorts of factors we think about, and we turn our mind to as many as possible when we're trying to make that assessment ourselves. Police will not have time to think about all those things. They will just make a judgment call, and sometimes that means they use more force than we think is necessary. But that is a matter of judgment, and reasonable minds do differ about that.
Thank you. Another question here. Did any of the content discussed by Skye or Anthony apply to the USA?
I'm not sure I fully understand that question. I did refer at one point to, not expressly, but I did draw on a US Supreme Court case in my preparation for my part. Sometimes case law from the US on discrimination issues can influence Australian discrimination law if courts refer to it, but the provisions of the laws in the US are quite different, and I'm no expert in those, so I'm probably not that well placed to answer that question, apart from saying that common law systems in countries like Australia, the US, Canada, and Britain do refer to developments in each other's jurisdiction when there is something useful on offer, and especially where there might be a domestic gap in the law, they may look to other decisions in another common law jurisdiction to fill that gap or to inform their reasoning on a particular issue. I hope that sort of answers that question. If the person wants to clarify if I'm off point, please do.
Thanks, Anthony. I think we will have to wrap it up there. But we have noted those other questions that have come through, and we'll respond by email or by Facebook. So sorry we can't get to those. But just before we finish up, I'd like to thank everyone so much for coming. Thank our presenters, Anthony and Sky, and our wonderful support people, our Auslan interpreters, Sean and Yasmin, and Caption and Lee. Really appreciate that today. And a final couple of points on the Royal Commission. As I said, you have until the end of this year to share your story and ideas for change with the Disability Royal Commission. There is free legal counselling and advocacy support available, and we'll provide those details in a moment. We'd love to hear from you, and you can scan the QR code that will pop up for any feedback that you have. There'll be a recording of the webinar that will be available on the Your Story Facebook page, and it will be added to YouTube as well in the coming weeks. And finally, if this webinar has raised any concerns for you, free counselling is available, and you can call them, Blue Knot, on 1800 421 468. Thank you so much, and hope to see you next time.
Thank you very much for having us.